Not every bit of truth is fit to be told. This is a proverb that is worth even in the media world. According to the National Communication Register, Cameroon has nearly 200 radio stations, 30 television houses, 100 written press organs, and 20 online media duly registered, though, for divergent reasons, some do not always fit into the traditional approach of informing, educating, and entertaining. Caught in a lawsuit, these media are then presumed guilty if all elements of news processing and dissemination are deliberately neglected. With Barrister Moore, it is first necessary to recall the legal framework of the presumption of innocence for all individuals, legal entities, and press organs who, suspected, charged, or accused, claim to have recourse to the defense. But before we will start from a larger framework to a more restricted framework, which is that of our country, we first have to understand that the presumption of innocence is dedicated in most international texts. I will refer you to the Article 11 in its first paragraph of the Universal Declaration of Human Rights, 1948, clearly stating the basis of the presumption of innocence, which also dedicates the protection by relevant institutions of the reputations and trustworthiness of the person prosecuted. And it is then for this reason you will notice that the entire investigation chain is secret. I insist on it. The entire investigation chain is secret. As from the moment that this secret is violated, we understand that the trustworthiness and credibility of the person who is subject to this investigation is undermined. And given that only a final decision by a competent court can establish whether or not a citizen is guilty, any evidence that will turn to give rise to a presumption of guilt or even a conviction of guilt will be a detriment to the image and credibility of the person concerned, as well as his trustworthiness and his personality. And it will be very dangerous for a person like that to have evidence that proves his official justification of guilt in front of the public's opinion. And hence, we understand that it opens the ground for infringements, including defamation.
Ouvre lieu à des infractions, notamment la diffamation.
Does it mean that the legal universal legislation is in accordance with the Cameroonian legal context? As I was talking about the secrecy of investigation, we have to know that the Code of Criminal Procedure, the presumption of innocence, the delusion of information are equally devoted to our penal text. At this, our code enshrines it. And let's not forget, since we are also talking about media as key players in the transmission and processing of information on a national or continental scale, the delusion of information by press means is also established. In a simplified term, a media that takes upon itself to present in an openly guilty person who is the subject of an investigation that has not yet been completed and who is not the subject of a final decision by a competent court is exposed to legal proceedings. Primacy of information is good. Priority and legal reflex is even better. For a press or regular citizen of social networks who would have fun shooting a point-blank range at a physical or moral person, Cameroonian law can deploy a tentacle on these entities. And this deployment will be carried out under two analyses. If we move into the mainstream media angle, that is, the radio, television, written press, there is already in our case law cases where media are being prosecuted and sentenced because a person has seen his image being destroyed, and especially if it has not been granted a right of reply, for that is what the law permits. The first demand to all those involved in a news item by a media is that this media owes him the right of reply. And if this person is deprived from the right of reply and sees his image destroyed, he has the right to demand for its reparation. With regard to the new generation, media more linked to information and communication technologies, the issue is a little more complex, and it's complex on two levels because the legal and community nomenclature is not yet keeping up with the pace of technological development. And so, being a new platform for social exchange and interaction, social networks are extremely dynamic. This is the first problem. The second problem is that beyond the legal framework, we must not forget that it is the first and foremost a social emanation, and as such, the actors of those social networks are strongly implicated or strongly influenced by what they read, by the way in which what they read is written, and by the way in which it is read out to them. Even if these platforms, these media are prosecuted or called to order, the impact they will have will go far beyond repression. And that's the danger, because today we have the impression that the media or social networks have become a new judicious body which can, when it wants, when it wishes, blacken or whitewash any person of his choice in an open resistance of his or her rights, in an open resistance of sometimes saying the truth, in an open resistance of the consequences that can be attached to these kinds of acts. Because don't forget that every citizen is a father, is a member of a community, is a company manager or an employee, is a colleague, is a neighbor, is a person as nice to see, and from whom one day to the next we see himself and the people linked to him affected by an information without being able to verify beforehand if his information is true or false. That is the real danger. But the complexity of social networks does not limit the change of criminal investigation according to the specific attributions of each link. So, it is not the investigating judge who will be self-referring, but the whole functional judicial chain or the chain of judgments composed of magistrates who, according to their different assignments, will have particular status. Some will be judges of judgment, others investigating judges, and others will be the public prosecutors. But from a textual and technical point of view, the guardian, once again as I said, of public morality and criminal law, is a public prosecutor. So, the public prosecutor has the capacity to take action on his own based on information that he has received. Moreover, if our memories are good, we go back a few months to the end of 2022, whereby a young lady has distinguished herself by a certain number of immoral images on social networks. And it did not need a private person to call upon for the public prosecutor to take action. The only thing that can be returned to is the obligation that is made to the public prosecutor to proceed through his collaborators of judicial police and other experts to verify the materiality of the facts. Once this is verified, and that the commission or the factuality of its offenses no longer to be discussed, this person is invited to justify himself. So, one can self-refer, but there is a framework that will involve the self-referral to the court of judgment. This space, which gives global visibility to what is published, brings a certain delicacy to the management of a media case. How to deal with the media and the secrecy of an investigation when you are a magistrate. It is very complicated. Why? Because we have at least major forces that put evidence of the magistrate's work on the streets. The first is freedom of information. The media, whether classical or the new generation, are always looking for a maximum of reliable sources close to the truth in order to keep their audience aware and on time. And for this reason, it is not usual to see certain media resorting to different deceits in order to get hold of the information. But once we situate ourselves on all that has been said previously, we understand that this information is only partial and fragmented, but information must be objectively concrete in order to be commented on. So, you have this first force that can undermine the protection of secrecy. You have the second element, which is the social pressure. This social pressure is sometimes strongly impacted by the media, by the information that is linked not only by the public but also by the community or by the neighborhood of the place where the offense was committed. You can imagine the assassination of an 8-year-old child out of school. You can imagine the state of the circumstances in which the parents of this child live. You imagine these young women, or let's say mothers, who will sit in front of the prosecutor's office all day in morning clothes, which, even without saying a word, is already a huge psychological burden on the representative of justice who is investigating on that matter. You have a number of proven or unproven statements that are made. So, you have this pressure which the investigating judge is going to bear. You have the media, and you also have the lawyer and the other judicial actors who, depending on which side of the fence they are on, can put pressure legally, of course, on the orientation of the public prosecutor or the investigating judge, or at least the magistrate in charge of the investigation in this case. So, imagine all these three forces simultaneous of relative importance and of relative degree of violence on the shoulders of a single person who remains, after all, a human being. And we haven't even talked about his conscience, because let's remember that in the magistrate's oath, he renders decision in the name of the Cameroonian people in respect of the laws, the facts, and also his conscience.
Il rend les décisions au nom du peuple camerounais, en tout cas, en respect des lois, des faits et aussi de sa conscience.
Media, social networks, each entity must contribute to the magistrate's conscience of applying verification, correction, confrontations of testimonies, and civic responsibility. This will certainly prevent us from taking the stand and being condemned by the court of neutrality and jurisdiction.